What is the beneficiary shortcut that often backfires? We recently had a viewer comment that says, you don't need a will, just put your kids on your accounts and call it a day. Let's talk about why that can actually put your family at some serious risk, especially if you have some minor children. I'm 𝗙𝗺𝗶𝗹𝘆, 𝗬𝗏. We're an estate planning practice in New York and New Jersey, and we provide peace of mind to families through our high client value services. If you are seeking assistance with either creating your estate plan or helping administer the one after the loss of a loved one, we can help, and we offer free consultations. You can find us at yourplanningattorney.com. And speaking of value, we're also here to educate as often as we can. So please ask questions and don't forget to share so together we can help some folks along the way. Now, yes, it is true, adding a joint owner on your account can avoid probate, but there are several red flags when doing so, especially if children are minors, or really even if they're just your children as adults. Let's go through them. I would think there's two major red flags when it comes to having minor children that you would add to an account. I don't even know if the bank would allow you to do this, but let's say you somehow get them on there, right? Adding your children doesn't necessarily provide any guidance as to who is going to manage those finances for the child. And if they're on this bank account, quite frankly, as minors, the bank is going to hold them until such time as they become an adult. And that can create a lot of issues. Secondarily, the court will get involved in the process because there are minor children who are receiving assets. So they are going to want to designate a guardian through the court process. And the only way that you have a say in doing so is by creating a last will and testament to say whom you choose to manage not only the livelihood of your minor children, but also the assets that they hold. So it is important that you do so. They're really not going to release it again until they're 18 or 21, I think, in some states. And at that point, they're going to receive it outright, which may not be the best guidance or thing for your child or then young adult. And of course, going through this process is going to increase the likelihood of court involvement with delays, legal fees, court supervision, all of those things. Now, that's typically, again, not what parents would intend or want for their children. Now, even if the children are not minors, right, and you've just designated your adult child as a joint owner, there's still other potential pitfalls, such as you're not getting creditor protection from the creditors of your children. What does that mean? Well, let's just say, God forbid, one of your children on your account gets into a car accident. Your account is accessible to that person who's suing them, the plaintiff. What if your child goes through a divorce? This is true of real estate. This is true of financial assets. That asset of yours, which you put your child on, is susceptible to being collected against, at least part of that litigation. It exposes your money. In addition, secondarily, you could create an accidental disinheritance. So let's say, again, you've added your children and one has a creditor issue and it diminishes your assets in some form or fashion. Well, you've just knocked the other children out of receiving some assets, correct? There could be, in the third case, some tax consequences with gifting, capital gains issues, which we've covered countless times relative to real property or other appreciated assets. And it can also have an impact on potential Medicaid planning for long-term care purposes. Lastly, I would say this is very common when a parent adds a child, one of the children that they trust, to their bank account, thinking it'll make things easier. It's true, that child will receive the assets, but then at your passing, they are 100% owner of that account. They, one, do not have an obligation to provide an equal distribution to your other children, which may have been your intent. And two, if they do decide to do so and distribute the assets, they then are facing a gift consequence potentially. So while you're trying to make it simple, you could be creating some more complexities. Creating a proper estate plan with a will and/or a trust allows you to name guardians and trustees for minor children and their inheritances. It does ensure the monies are going to be held safely for the children without impacts of creditors for yourself and for them. And it gives you control on how the distribution is going to take place. And truly, every family does deserve clarity, safety, and true protection and seamless transitions at every stage. Getting a proper estate plan is the safest and easiest way to achieve that. Certainly, if you have any questions at all, please drop them below. We are here to help. Again, Valerie Zammitti of Zammitti Law. We're an estate planning practice in New York and New Jersey. If you need our assistance, you can find us for a free consult at yourplanningattorney.com. Hope you've learned something new here today. Don't forget to share and take care. Bye-bye.